5 landlords who own a dozen properties on East Post Road in White Plains, across from White Plains Hospital, have gone to court in opposition to the City Urban Renewal Agency's move to take those properties by eminent domain. The action was filed as provided for in Section 207 of New York State's eminent domain procedure in the Appellate Division of State Supreme Court in Brooklyn. The attorney for the landlords, Leanne Watkins of the White Plains-based law firm Watkins & Watkins LLP, views the East Post Road eminent domain proceeding as different from others she's seen.
I've never seen one like this one, where the municipality has deliberately failed to select or publicize their public purpose. They threw out a whole bunch of possibles and then included a catch-all, which is anything else we ever come up with, and they haven't selected one. So I've never seen a project like that. We're here saying that they shouldn't have the right to go forward with their, non-selected public purpose. They really should have selected one, and then they should have done the required environmental analysis based on that selected public use or purpose. And it's usually very specific and very detailed, and in many respects it needs to be, so that they can do the environmental analysis. Here, by not selecting the purpose, they essentially skipped the environmental review, and they said that they looked at the transfer of title from the current owners to the city, and then decided that has no environmental impact. Well, of course not, as it never would, but they're pretending that there's no demolition and no construction to look at in terms of an environmental review, which completely misses the point of the statutory requirements and makes it quite laughable. But normally they would just come out and say what it was, and we could all say, okay, maybe we don't like it, we don't like the money, but it's a public purpose. Here, they had a whole list. I think there were 5 or 6 that I identified, or the catch-all, or anything else we come up with. And that's not really fair. I mean, it's not fair to the property owners to evaluate whether they think that's right. It's not fair to the public. It's not even fair to the appellate division, who's supposed to look and say, is this a public purpose? You didn't give them enough information to make that decision. And unfortunately, most egregious here is the failure to comply with the environmental review. I truly hope that the court will throw this out because they failed to comply with that.
As a landlord, it's very sad. But I approach everybody. I had a meeting in my office with most of them. Not everybody can come because working hours. And with COVID, it's very difficult to get together. So I went and visited every one of them with a distance protocol, whatever. And they were very sad. They had to move. They're very comfortable. Many of them lived there for many years. And then it's very sad to give them the news. But if I had to do it, I don't have no choice. I own a lot of property around the city, and I support the city because the city has been good to me and to many other landlords. We housing individuals that nobody can rent. Means you're talking about landscaping, dishwashers, all these individuals who come like me to this country without a penny. America is the greatest country in the world, no doubt about that. This is my concern. Where are they going to relocate these people for the same amount of money that they're paying me? The maximum standard they can live for the kind of money they're paying for. And this is what all the things is upsetting. Because where are they going to go? They can't afford to pay for one bedroom $2,000, $3,000 and maybe more than that.